In his final days in office, Joe Biden issued a statement claiming that the Equal Rights Amendment is now the law of the land, claiming to have ratified effectively, retrospectively, this 28th Amendment, allegedly. And this has been called out by critics as an unconstitutional abuse of power, which is very clearly and evidently the case. Presidents do not have authority to legislate, and they do not have authority, certainly, to make constitutional amendments. So an executive order decreeing a constitutional amendment into existence is clearly such a laughable thing that no serious proponent of liberty should ever want to have such a character in office ever again, nor set anyone up for such an abuse of power, because this is just frankly ridiculous. And the argumentation here advanced by the American Bar Association and so on is just absolutely ludicrous. It has not been ratified. Anyway, the community note here says that there was a deadline set on it originally by Congress, and that deadline has expired and so on. So leaving this behind in the dust, it's important for us to consider now what this is doing here. This is an executive order that Donald Trump signed during his first day in office, titled Protecting the Meaning and Value of American Citizenship. And not going to lie, right out of the gate, I am very enthusiastic about this idea that we should protect the meaning of American citizenship. I have some ideas and recommendations on how to do that go beyond this executive order in meaningful ways. But let's dive into how he proposes to implement this. And of course, he goes and says it's a privilege to be a citizen of the United States. I agree with that. And he cites the 14th Amendment, saying all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And to be honest, I do have issues with the 14th Amendment and the way that it's worded and the way it's been executed. I'm not a believer in just because you were born in a certain place, you are therefore a citizen of that country. That creates numerous loopholes for exploitation. And as we'll see here, yes, those loopholes have been exploited. 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Okay, so it says, and that is part of the wording, that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay, so, and that is kind of curious language, honestly, to include in that. And at a high level, I understand the intent here is pretty straightforward, at least as perceived by Republicans and so on in the United States. The idea is that people shouldn't be allowed to just come here illegally, have a baby, and have that baby be a United States citizen and have all the privileges of United States citizens. And this makes sense. I don't believe that people should be able to cross the border illegally or overstay a work visa or be not permanent residents, and yet have their children born here and then just magically have them be citizens. But simply put, interpreting a constitutional amendment in such a way as to materially alter that is problematic. So in particular, I'm going to zero in on this claim here. The 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. This is a contested issue, in fact, and Trump claiming to have authority to settle the matter of what the Constitution means on this point really does transgress the bounds of his office. Taken at face value, this executive order is in fact alleging to substantially alter or interpret the meaning of a constitutional amendment. In effect, doing the same thing that Biden did by inserting language into the Constitution or stipulations on it that did not exist previously. And he's doing that, very curiously, by this subject to the jurisdiction thereof clause. Because if not for that clause, then just anybody who's born here would indeed automatically be granted citizenship. But there are several additional legal and constitutional contradictions that come into play if one insists that children of illegal immigrants are not subject to the jurisdiction of the United States. And this is very dangerous point that I want everyone to consider. Anyway, he goes on to say that there are those who are born in the United States, not subject to its jurisdiction. He says, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, various work visa and other programs, visiting, student, tourist, whatever, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. And in the order, it sets forth this alleged policy. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons who meet either of those previous qualifications. And of course, there's, to rebut any concerns about ex post facto, this shall only apply to those born within the United States after 30 days from the date of this order. Nothing in this order shall be construed to affect the entitlement of other individuals, including children of lawful permanent residents, to obtain documentation of their United States citizenship. So there are several issues here. One, just as a rule, the executive branch of the government does not create binding policies. It is not a policy-making or a law-making body. And so by saying the policy of the United States shall be such and such, that is subsuming a function of Congress that is not constitutionally legitimate because it transgresses the separation of powers. The function of the executive branch is to execute and implement, to carry out the laws that have been ratified by Congress. Another constitutional problem here is that the head of the executive branch is taking it upon himself to interpret the Constitution, and specifically to interpret a constitutional amendment in such a way that materially affects its application. And if that, and the corresponding policymaking supposedly pursuant to that had not been enough, first of all, it cannot possibly be true that children of illegal immigrants who are born here within the United States are not subject to the jurisdiction of the United States. Because within the text of the Constitution itself, Article 3, Section 2, it explicitly states that the judicial power shall extend to all cases in law and equity arising under this Constitution, laws of the United States, and treaties made, or which shall be made under their authority, to between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof, and foreign states, citizens, or subjects. So this right here is a problem because this explicitly grants the United States jurisdiction in controversies between the citizens of the United States and foreign states and its citizens or subjects. Isn't that interesting? So by disclaiming that particular part of the judiciary's authority, Trump is here claiming that these children of illegal immigrants and people overstaying their visas and so on are not subject to the jurisdiction of the United States. This creates very serious problems because, among other things, this would completely prevent the United States government or any branch, any office, any judge, anything from dealing with the children of illegal immigrants and people who've overstayed their visas and so on. It would prevent them from having anything to do with them under the auspices of a legal proceeding because they would not have jurisdiction. Notably, the executive order does not contradict the jurisdiction of the United States over the parents of those children. But what that means in practice is that you could have a trial in which the verdict is that the parents are guilty of, criminal trespassing, illegal occupancy, having crossed the border or overstayed a work visa or such and such. But then they couldn't do anything about the children They could deport the parents, but that would separate the parents from their children because they're not allowed to have jurisdiction over the children. Isn't that interesting? There are a number of countries that have laws that state that the children of their citizens shall also be citizens of their mother country, regardless of where they're born. And so those countries would claim those children pursuant to their laws as their own lawful citizens. But there are also instances where such citizenship rights are not granted by the mother country, which would effectively orphan those children nationally. That is, they would have no national identity, no citizenship anywhere. They would just fall through the cracks and basically not be regarded as having civil rights anywhere. And that creates a huge problem, especially for those who are of the godless atheistic interpretation that governments grant rights, which we know is not true. Governments do not grant rights. Governments exist to protect rights. And so this gets into the matter of human rights as opposed to alleged civil rights. In reality, there are no such things as civil rights. They're all human rights, or else they are privileges conferred upon citizens of a particular nation or state, and so on, right? All other topics aside, all other matters aside of constitutionality and so on, this creates a very troubling jurisdictional gap. And the children of these illegal immigrants and the children of those who are not lawful residents, what's going to happen to them? There's this loophole that's introduced here. Is that intentional? I understand the main issue that he's nominally going after here is they shall not be citizens of the United States. But the argument that he's using to do that is that they are not subject to the jurisdiction of the United States. So then, in theory, the officers of the law in the United States can't deport them. They can't do anything to them. Or can they? But they can deport the parents. Anyway, this is concerning because it does contradict the Constitution directly on that point. And I would submit for your consideration also the heading that our government has typically chosen to process deportation hearings under is an administrative proceeding, which, by the way, is not an authorized way to fundamentally alter someone's life under the Constitution. For those who have had experience with family courts, you know that in the United States, the court precedents treat family court as a civil matter rather than a criminal matter. But not just as a civil matter, they treat it as a different designation, a different type of hearing, one that they say the parties are generally not entitled to a jury trial. And they'll make up various excuses like, oh, it's sensitive matters, or family privacy, or they'll say you can't prosecute that, or you can't go to civil court because it's not a matter of common law, it's a matter of state law, which is just a lie, by the way. Common law means the law that is common to the people, whatever they decide, and the authoritative body for deciding what common law is the jury, not the judge. Judges don't get to decide what common law is. Juries do. They are the common people. By definition, by nature, they establish the common law. They decide what is fair. They decide what is equitable. And especially in matters where you're separating a family, dividing them up, and having these huge repercussions against them, court orders, restraining orders, etc., you need to have a jury involved. The Constitution provides that all civil cases, that is to say, all matters of common law, the parties have a right to a jury trial if the matter in controversy exceeds $20 in value. Human beings and family relationships vastly exceed, they infinitely exceed $20 in value. And so every single family court case should be heard by a jury. Summary judgments and bench trials have no business interfering in family matters. If they are to be heard under the jurisdiction of the United States or of any government, it has to be a jury trial. That is the meaning of common law. How many people have been shortchanged and just robbed of their rights, robbed blind in these private, unconstitutional hearings? The Constitution makes no provision for any other kind of hearing. There is no such thing as an administrative proceeding, infraction, or whatever designation you want to paint on it that can justly deny you your constitutional rights. Anytime a government entity is involved as a plaintiff, it is by definition a criminal case. If the plaintiff is a non-governmental entity, then it is not a criminal case. And there are really only two designations, suits, that ordinary people could bring up: matters of common law and criminal cases. Those are the two designations. The government doesn't just get to make up new classes of things, call them different things, and deny people their rights. Same thing is going on here. So take a step back and just think about what we're doing. If the federal government gets to hold these administrative hearings and just deport parents, and goodness knows what happens to the children, I take serious issue with that. So what needs to happen here is it should be acknowledged that, per the Constitution itself, any controversy between the people of our country and those who are subject in any way to the authority of any other country, and this would include those descending from other nations, they would indeed, by bloodline, be subjects by definition, unless they're naturalized as ours. Do you understand? So there should be no children falling through the cracks here. But Trump's executive order creates that gap and exploits it. What should happen is that in every case, per Article 3, Section 2, Clause 3 in the United States Constitution, the trial of all crimes, except in cases of impeachment, shall be by jury. And it should be a jury of one's impartial peers. And by the way, this is a human right. There's nothing in the Constitution, there's no language that limits the trial of crimes on the basis or by designation of whether or not someone is a citizen. And in case anyone is confused on that point, I have here the Declaration of Independence. Most people, I think, have forgotten what it says. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Per our nation's own founding documents, all human beings are created equal, having the exact same unalienable rights, which are given to them not by the government, but by our Creator, who is God. So, in addition to just coming up with a constitutional amendment or interpretation of his own, this jurisdictional loophole is very troubling and very concerning, especially coming from a president who claims to be all about protecting the children. These children are not going to be protected if they are deemed as not subject to the jurisdiction of the United States. We've seen this with all kinds of bad precedents and bad legislation. The government cannot protect what it refuses to define. If it refuses to acknowledge the definition of a woman, I guarantee you, women's rights will be disrespected. If it refuses to acknowledge the family unit, I guarantee the family will be disadvantaged. If it fails to acknowledge the true definition of marriage, marriages will be trampled upon by our government. If our government refuses to acknowledge the identity and definition of a human being, it will fail to protect the rights of human beings, including the unborn. See, this is our problem. Roe v. Wade and the precedent that supposedly overturned it, in reality punted on the question of what is a human being, pretending that it was a states' rights issue. What they were really declaring is that the federal government refuses to protect the lives of the unborn, which, in many ways, is simply continuing the precedent. It is true that they relaxed the binding nature of the thou shalt, but the federal government itself has been refusing to step up and protect the rights of the unborn, who are human beings. They haven't been born yet, so they can't be citizens, and yet they are within the jurisdiction of the United States, as acknowledged for generations. And as hundreds of millions of babies have been snatched from the womb and aborted. They have human rights. They are human beings. And in similar fashion, in continuation of that terrible legacy, this executive order creates another jurisdictional gap for children to fall through. The Church of Jesus Christ of Latter-day Saints has issued an official statement on the subject of immigration, stating, "As a worldwide church dealing with many complex issues across the globe, the Church of Jesus Christ of Latter-day Saints promotes broad foundational principles that have worldwide application. We follow Jesus Christ by loving our neighbors. The Savior taught that the meaning of neighbor includes all of God's children in all places at all times. We recognize an ever-present need to strengthen families. Families are meant to be together. Forced separation of working parents from their children weakens families and damages society. We acknowledge that every nation has the right to enforce its laws and secure its borders. All persons subject to a nation's laws are accountable for their acts in relation to them. Public officials should create and administer laws that reflect the best of our aspirations as a just and caring society. Such laws will properly balance love for neighbors, family cohesion, and the observance of just and enforceable laws." If this executive order amending the 14th Amendment were true, then it would create an unenforceable jurisdictional gap that would have the effect of separating parents from their children. And as children, where would they end up? And yes, within the United States, the Church has yet again affirmed these exact same principles, that the federal government has an obligation to secure its borders. So all of this does indeed directly say that, yes, we should have secure borders. Yes, we should have wholesome vetting of immigration. And the judicial power, the United States judiciary does in fact have jurisdiction over foreign nationals, their children, and so on. No one falls through the cracks. If it's a controversy between ourselves and anyone else, frankly, the trial of all crimes shall be by jury. And you can't prosecute it under any other disguise. That is just evil. So we need to hold jury trials and not tolerate the separation of families. So I believe that people should come here legally. If they're here, they should stay legally. Parents should not be separated from children. Children should not fall into jurisdictional gaps. They should remain together with their families. The family unit has its own sovereignty that surpasses that of the nation itself as a cohesive entity. If anybody's born on the earth, the fact that they don't seem to have an apparent national origin or identity should not dampen in the least our enthusiasm for protecting their human rights, including defendant rights if they're accused of any crime, whether it's trespassing here illegally or getting a speeding ticket or whatever. And here's the process that I will recommend is, yes, end birthright citizenship for illegal immigrants, but also provide a path for naturalization to anyone who is able to qualify. And the criteria are actually quite simple. It's loyalty to our Constitution and renunciation of all foreign allegiance. That's what our oath of naturalization is and says. And I believe that every citizen of the United States, even if we were born to citizens of the United States, I believe every American would do well to embrace this oath and to make it when they come of age, as a prerequisite to voting, for example. I hereby declare on oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty, of whom or which I have heretofore been a subject or citizen, that I will support and defend the Constitution and laws of the United States of America against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I will bear arms on behalf of the United States when required by the law, that I will perform non-combatant service in the armed forces of the United States when required by the law, that I will perform work of national importance under civilian direction when required by the law, and that I take this obligation freely, without any mental reservation or purpose of evasion, so help me God.